Embarking on the journey to live and work in the United States is a life-changing event. One of the first and most important decisions you will face is how to handle your immigration application. Should you navigate this complex process by yourself, or should you hire an experienced immigration attorney to guide you? Many people consider filing their immigration petitions on their own, a path known as pro se filing. The primary motivation for this is often to save money on legal fees. For those with straightforward cases, such as a simple family petition with no complications, filing pro se might seem manageable. Government websites like USCIS offer forms and instructions for free. However, the U.S. immigration system is notoriously complex and constantly changing. The forms can be confusing, and a small mistake can lead to long delays or even a denial. This is why many people choose to hire an immigration attorney. An attorney brings legal expertise and experience to the table. They understand the nuances of the law and can represent you in communications with government agencies. Ultimately, the choice between filing pro se and hiring an attorney is deeply personal. This guide is designed to help you understand the differences between these two paths. The decision to file an immigration petition by yourself or with an attorney is more than just a matter of convenience or cost. The outcome of your application can determine your ability to live with your family, pursue a career, or find safety in a new country. A successful petition opens doors to new opportunities, stability, and the chance to build a life in America. A denied petition can lead to devastating consequences, including separation from family members or even being forced to leave the country. Consider a U.S. citizen who wants to bring their foreign spouse to live with them in the United States. A simple mistake on the I-130 petition for alien relative could lead to a request for evidence or RFE. This not only delays the process by months but also adds stress and uncertainty to the couple's life. The stakes are even higher in more complex cases. For example, an individual applying for asylum is seeking protection from persecution in their home country. Their very safety depends on the approval of their application. An attorney specializing in asylum law can make a critical difference. Understanding the risks and benefits of each approach is a practical necessity for anyone entering the U.S. immigration system. Your choice will directly impact the likelihood of a smooth and successful process. By weighing your options carefully, you are taking the first and most critical step in protecting your investment of time, money, and hope for a new beginning. The immigration journey officially begins with the preparation and filing of an initial petition. The specific form you use depends entirely on the type of benefit you are seeking. For example, a U.S. citizen sponsoring a spouse would start with Form 130, Petition for Alien Relative. Each form comes with a long set of detailed instructions that must be followed precisely. Preparing the petition involves much more than just filling out a form. You must gather a substantial amount of supporting documentation to prove your eligibility. This evidence can include birth certificates, marriage licenses, passports, financial records, employment letters, and sworn affidavits. Each document must be a perfect copy, and any document not in English must be accompanied by a certified translation. Once you have completed the form and assembled all your supporting evidence, the next step is to mail the entire package to the correct USCIS lockbox facility. Sending your petition to the wrong address is a common mistake that can cause significant delays or even lead to the rejection of your filing. You must also include the correct filing fee, which can be several hundred or even thousands of dollars. This initial filing stage sets the tone for your entire immigration case. A meticulously prepared, well-documented, and correctly filed petition creates a positive first impression. Conversely, a sloppy, incomplete, or incorrectly filed petition immediately raises red flags. This is where the complexities of the system first become apparent, and where the decision to seek professional guidance can start to show its true value. After you have successfully filed your petition, you enter what is often the longest and most anxious phase of the immigration process, the waiting period. Once USCIS accepts your package, they will send you a receipt notice, typically Form 1797C, Notice of Action. This notice is incredibly important as it contains your unique receipt number, which you can use to track the status of your case online. Processing times can vary dramatically depending on the type of petition, the service center handling your case, and the overall caseload of USCIS at that time. During this waiting period, you will likely be scheduled for a biometrics appointment. At this appointment, USCIS will collect your fingerprints, photograph, and signature. This information is used to conduct mandatory security and background checks. The biometrics appointment itself is usually straightforward and quick, but it is a required step that you cannot miss. One of the most common complications during the waiting period is receiving a request for evidence, or RFE, or a notice of intent to deny, or NOID. An RFE means the USCIS officer reviewing your case needs more information before they can make a decision. A NOID is more serious and indicates the officer believes you are ineligible and plans to deny your case unless you provide new evidence to convince them otherwise. Responding to an RFE or NOID is extremely time-sensitive. This long and uncertain waiting phase is often where the stress of the immigration process truly sets in. This is where having an attorney can provide significant peace of mind. As your case nears its conclusion, you will likely face one of the final and most critical hurdles, the immigration interview. For many types of petitions, such as marriage-based green cards and naturalization applications, an in-person interview with a USCIS officer is a mandatory step. The purpose of this interview is to verify the information in your application, confirm your eligibility, and ask follow-up questions. The officer will have your entire file in front of them and will go over your answers and documents in detail. Preparation for the interview is absolutely essential for success. You will need to review your entire application and all the documents you submitted, since you can be asked about any detail. For a marriage-based interview, both spouses must attend, and the officer will be assessing the authenticity of your relationship. An attorney can play a vital role in this final stage. A good lawyer will conduct a thorough preparation session with you before the interview. They will review potential questions, practice your answers, and ensure you have all the necessary original documents to bring with you. On the day of the interview, the attorney can attend with you. While they cannot answer questions for you, they can clarify the officer's questions and ensure the interview is conducted fairly. Finally, after the interview, you will receive the final decision on your case. Navigating this post-decision process is legally complex and has strict deadlines. The U.S. immigration system is a complex, ever-changing maze. Forms are legal documents. Using an outdated version or missing a new rule can mean instant rejection. Policies shift quickly, and government websites may not reflect the latest changes. Many Pro-C applicants, despite their best efforts, find themselves lost, facing denials for reasons they never saw coming. In immigration law, even the smallest mistake can cause major delays. A missed signature, typo, or unchecked box can lead to your application being rejected and sent back, costing you precious time. Inconsistent or incomplete information raises red flags, sometimes resulting in months-long delays. One moment of inattention can turn a simple process into a stressful bureaucratic ordeal. In U.S. immigration law, the burden of proof is always on the applicant. Just submitting forms and basic documents isn't enough. Officers are trained to be skeptical and require clear, convincing evidence, especially in cases like marriage-based green cards. You must go beyond just the facts and provide a compelling story with strong supporting documents, or risk denial, even if you're fully eligible. Once your petition is filed, all official communication about your case will come directly from a government agency, usually USCIS. This correspondence is not always easy to understand. The letters are often filled with legal jargon, acronyms, and references to specific sections of immigration law. For a pro se applicant, receiving a letter like a request for evidence, an RFE, can be incredibly intimidating and confusing. The letter may ask for evidence to establish a qualifying relationship or to overcome a ground of inadmissibility without clearly explaining what those terms mean in plain language. Misinterpreting what the letter is asking for is a significant risk. Responding incorrectly to this official correspondence can be fatal to your case. If you receive an RFE and misunderstand what USCIS needs, you might send back the wrong documents or, just an incomplete explanation. Because you typically only get one chance to respond to an RFE, a weak or irrelevant response will likely lead to a denial. The deadlines for these responses are also extremely strict and non-negotiable. If the letter says you have 87 days to respond, that is exactly what you have. Missing that deadline even by one day will almost certainly result in your application being denied for being abandoned, with very limited options to appeal. Furthermore, the government is not proactive about helping you. USCIS will not call you to clarify what they need or to remind you about an upcoming deadline. The responsibility for managing all communication falls entirely on the applicant. This includes keeping your address up to date. If you move and forget to file Form AR-11, the change of address form, USCIS will continue sending crucial notices to your old address. If you miss a notice for a biometrics appointment or an interview, your case can be denied without you ever knowing there was a problem until it is too late. This simple administrative task, when overlooked, can undo months or years of progress. This communication gap creates a high-stakes environment where the pro se applicant is at a constant disadvantage. They are expected to interact with a complex bureaucracy, using a specialized legal language they do not speak. They must interpret dense requests for information and meet rigid deadlines without any guidance. An attorney, on the other hand, acts as a professional interpreter and intermediary. They understand the language, know exactly what the government is asking for, and are trained to manage deadlines and communications effectively. This removes the risk of a simple miscommunication derailing an entire immigration journey. Hiring an immigration attorney means gaining a strategic expert, not just a form filler. They analyze your unique situation, identify the best path, and craft a persuasive legal case. With deep knowledge of evidence and requirements, they anticipate issues and present your story convincingly. This expertise and preparation set your case up for success from the very beginning. An immigration attorney is your bridge to the government, handling all official correspondence and communications on your behalf. This relieves your stress and ensures you never miss important updates. At interviews, your attorney is your advocate and shield, keeping the process fair and focused. With an attorney, your voice is heard and your case is protected. Even the best-prepared immigration applications can face unexpected challenges. When panic sets in, an experienced attorney becomes your crisis manager, analyzing problems, outlining solutions, and acting fast. Whether it's a denial, a court notice, or a simple mistake, a lawyer brings calm, expertise, and a plan, ensuring you're never alone when the unexpected happens. Does hiring an attorney really make a difference? Studies consistently show that applicants with legal representation have much higher success rates, especially in complex immigration cases. Data from sources like Syracuse University and the Stanford Law Review reveal that having a lawyer can dramatically improve your chances of approval. The numbers are clear. Legal representation is a powerful advantage. Attorney-led cases succeed more often because lawyers provide expert quality control, catch errors, and ensure every document is complete. They know what evidence convinces USCIS, anticipate legal challenges, and handle deadlines and communication professionally. This strategic approach, from assembling strong evidence to managing interviews, gives clients a clear advantage and greatly increases the odds of approval compared to going it alone. While statistics favor hiring an attorney, your own situation matters most. If your case is complex or involves risk, the data shows a lawyer can make a real difference. Denials can have lasting consequences: lost time, money, and even risk of removal. Use the numbers to make an informed choice and give yourself the best chance of success. When your future in the U.S. is at stake, like facing deportation, removal, or seeking asylum, having an experienced immigration attorney is critical. The government will have a trained lawyer, and the legal process is complex. The risks of going it alone are simply too great. In these moments, investing in a skilled attorney is not a luxury, it's a necessity. Immigration cases can seem simple, but hidden complications like criminal records, visa overstays, or complex family histories can quickly arise. An attorney's expertise is crucial when your case isn't straightforward. The U.S. immigration system leaves little room for error. If there's anything unusual or complicated about your case, legal guidance can make the difference between success and denial. Navigating the U.S. immigration system is a major decision, whether to go it alone or hire an attorney. Filing pro se can save money but risks costly mistakes. An experienced attorney offers expertise, reduces errors, and increases your chances of success. The data is clear. Legal representation leads to higher approval rates, especially in complex cases. Investing in an attorney is investing in your future and peace of mind. Making this decision can be tough. Start with an honest self-assessment. If your case is complex, seek legal counsel. Research attorneys, check credentials, and trust your instincts. Compare costs, but remember, the right help can save you time and stress. In the end, choose the path that gives you the most confidence and peace of mind.